SJC-13696, Arrowood Indemnity Company versus Workers' Compensation Trust Fund.
Okay, Attorney Smith.
Good morning, and may it please the court. I'm Eric Smith, appearing for Arrowood Indemnity Company. Arrowood asserts a claim for second injury reimbursement because payments made while it was in runoff.
Can you talk a teeny bit louder? Sorry.
Absolutely. And also step closer to the mic. Arrowood has pursued this case because we believe that the earlier decisions in Panu, affirmed by Home, on which the reviewing board relied in this case, were wrongly decided. Two essential reasons. First of all, they do not correctly interpret the statutes, as the appeals court in this particular case concluded. And then second of all, because those decisions, in particular Panu, was based upon a flawed assumption that the result for the trust fund is the same where an insurance company stops writing new policies and enters runoff as where an employer opts out of paying assessments. When an employer opts out, the trust fund loses the assessments it would otherwise receive from that employer. When an insurance company stops writing new policies, the trust fund continues to receive assessments because the former insureds of that insurance company must move on to other insurance companies because they're required to have insurance, workers' compensation insurance, and they then pay their assessments through those insurance companies. Turning first to the statutes, here, in our view, the statute speaks clearly under ordinary principles. First of all, the plain meaning of the statute, which is that 37 mandates second injury reimbursement and subject to a proviso. And that proviso refers to the opt-out provisions of Section 65, which concerns employer mostly self-insurers, but the employers as in the capacity of employers who can file a notice of non-participation, stop paying assessments, and the price of that, of course, is that they don't receive the reimbursement. There's no provision in the statute that prohibits reimbursement to insurance companies in runoff or that requires an insurance company to deposit assessments as a condition to receiving reimbursement. And just referring to the statutory principles that are discussed in our brief, it's well established that where the legislature enacted a statute subject to specific exceptions, agencies and courts do not imply other exceptions, and the courts regard those omissions as purposeful. That plain meaning, which the appeals court concluded, is confirmed by reading the Workers' Compensation Act as a whole, looking at some other provisions. First of all, it's consistent with the evident legislative intent for the exceptions in Section 34B, Section 37, and of course, spelled out in more detail in 65, which is that under those exceptions, the employers who would otherwise pay the assessments can choose not to pay those exceptions and then lose reimbursement. That's their intent. That intent doesn't encompass this situation where the insurance company, there's been no opt-out, insurance companies can't opt out, they don't pay, and the trust fund continues to receive assessments from the employers. Reimbursement also serves the purpose of Section 37, which is to promote the hiring of injured workers. Where an insurer receives reimbursement, that reduces the employer's premiums, either directly if they're a self-insurer or through the adjustment of the experience modification factor if they're insured by an insurance company. Denying the reimbursement denies the employment that statutory incentive and deprives them of the incentive that they had to hire previously injured workers. And finally, the reimbursement is consistent with the purpose of protecting insurance companies, which is evident from paragraph 4 of Section 65(2), which permits a public employer who's insured by an insurance company to opt out, which of course deprives the trust funds of assessments. In that case, the legislature denied reimbursement from the trust fund, but required that the employer actually itself reimburse the insurance company. So clearly the legislature contemplated that an insurance company that issued a insurance policy, started paying on a claim, was getting reimbursement, would continue to do so.
I find your plain reading clear, and I'm not belaboring that. So I'm trying to get at why the DIA is so concerned about the Workers' Comp Trust Fund and the impact of this kind of problem. And I don't get it, right? Because this plaintiff's continue, when the employer shifts, somebody is still putting money into this fund, right? Right? What happens here? Describe what happened, just the facts of the case as Justice Wolhogen did. Do the facts of this case. and how the money kept flowing here, right?
Well, in this particular case, Arrowood obviously wrote the insurance policy in 2001 to Scully. The employee, Pena, was injured in 2001, at which point Arrowood started making the workers' compensation payments. After it was apparently satisfied the conditions for a second injury reimbursement. Right. So after 2 years, 104 weeks as in the statute, the second injury reimbursement provisions kick in. And then there's a lag because the insurer has to submit the request for reimbursement, and it has 2 years by statute to do so. Now that the insurer, Arrowood, which was by then in runoff, because it went into runoff in 2003, right, submitted requests for reimbursement, which were paid through 2013 roughly, at which point the Panu decision came down and the position
Right,
shifted.
but the plaintiff has a new insurer. That new insurer is contributing to the Workers' Compensation Trust Fund, correct?
That's correct.
So there's not a negative impact on the worker, because it seems like, I understand again the importance of that Workers' Comp Trust Fund, and particularly in 1991, because the system was blowing up. So I'm trying to understand what's happening when they write this language. And is there any argument? Do the insurers contribute in any way to the Workers' Compensation Trust Fund? Do they have any payments into the Workers' Compensation Trust Fund? Or is it totally paid for by employers and the insurers just act as a conduit?
My understanding is that and looking at the statutes, is that it is simply the insurers are a conduit. They do not themselves fund the trust fund, which is...
But the insurers do provide information to set the next year's assessments, right?
Yes, they provide information.
And an insurer in runoff period no longer is doing that.
That's not correct, Your Honor.
Oh, is that? Okay,
yeah,
so explain to me how that happens.
There's two aspects of the argument that the trust fund had made before and the reviewing board adopted was the participation argument. In their recent brief, they argued that Arrowood was not complying with the brief. The record is not fully fleshed out on that point, but it does include one stipulations that, statement, testimony, and I basically find the site here. Ms. Feaster of the DA.
Wait, just to cut to the chase, is it your position that an insurer in runoff reports to the trust fund?
It continues to report. The record shows here the filing of the Form 50s, which, as Ms. Feaster testified, is the DIA's way of obtaining information about assessments.
Okay.
And
okay.
And the insurer in runoff continues to file Form 50s.
Our Form 50s are the form that says we're paying these benefits. Is that
It says we are paying these, we have collected, well, actually, to be more precise, it specifies that we have collected the following assessments, which we are now obligated to turn over to the trust fund. Here, of course, Arrowood in runoff doesn't have any current insureds and therefore has no assessments to act as a conduit for because assessments are collected from the current insureds and Arrowood doesn't have any. It's continued to comply with its obligation to file the Form 50s, but it's not reporting any
so the Form 50
assessment.
Contains no information?
Yes.
Okay.
Yeah, the Form 50s because there's no information to provide because there has no current insureds from whom to collect. So in our view, Arrowood is complying with the statutes as they apply to it. It doesn't have any current insureds and therefore doesn't have any information to provide other than reporting that it doesn't have information to provide. With respect to...
The DIA decision where they talk about the negative effect of this, what's your response to it? Again, because I don't quite follow it, but the DIA, we owe deference, these people are experts, we owe some deference to their discussion that not having these insurers in this status, whatever the status is, has an impact on the Workers' Compensation Trust Fund. And I'm just trying to understand what your response to that is and how we deal with that, given that we owe them some deference.
Well, 2 points. First of all, in our view, there is no impact because the assessment base is not affected and their ability and the collection of assessments from the current employers who are the assessment base is not affected. So in our view, there is no impact on the trust fund. With respect to the deference point, obviously in our view, the statutes are clear, but moving beyond that, the reason that Arrowood presented a record in below.
They aren't really making a statutory they're suggesting that almost as a fact-finding of some sort by the DIA, that this administrative burden that's imposed when your clients check out, because they don't rely on it as a statutory interpretation, right? They have this, they sort of back into this.
Yes. And the administrative burden argument, I think, Your Honor, has arisen in response to one paragraph in the appeals court's decision, which in our view is essentially was just sort of saying that employers need to participate, and participate means they are required to do so unless they file a notice of non-participation. So it's not an issue. And then they refer to Scully, which was, as an example here, we showed, of course, in the record that Scully was insured by many other insurance companies through the time of the hearing, and therefore was obligated to, pay in.
I wasn't talking about Chief Justice Green's decision. I'm talking about the decision by the reviewing board, which seems to be concerned about the effect of going into this status where you don't report, or you don't have any, that you somehow burden the system. Because that doesn't, we owe some deference to them on that, as opposed to pure statutory language, which I think you do a very nice job of explaining how the statute works.
Well, Your Honor,
I don't know how important it is, but they do make.
in our view, they sort of, it becomes, as in the words of the other side's brief, the connective tissue. I mean, these are very large, broad, general, sweeping statements. In our view, they lack substance because there is no actual impact. The insurers in runoff continue to file the required forms. And of course, to the extent that there were any actual non-compliance with anything, there's a remedy in the statute. I mean, failing to provide information for the assessment base is subject to a $1,000 fine under, and I don't know whether it's daily or not, but it's subject to a fine under Section 65(3). Failure to transmit assessments, of course, there are none here, are subject to liens and fines under 65(5). So there are remedies for non-compliance type issues. I'm just not certain that there's any actual burden other than the fact that it has to pay reimbursement on the trust fund.
Meaning that if they don't pay the reimbursement, the trust fund has more money.
Exactly.
Right, it puts less pressure on, and the trust fund does a lot of different things besides paying COLAs and second injuries. It pays for the DIA's expenses. It pays for workers' comp benefits for uninsured employers too, right? Is that? But again, insurance companies don't pay any of that, right? It's all done on employers.
It's done on the assessment base. I mean, Section 65 is quite clear. The revenues for the trust fund shall be obtained from an assessment on all employers subject to this chapter. So that the legislature is clear that this is supposed to, the whole system is funded by employers in the current year. And the reason for that, and to some extent, I think, is the fact that employers do go out of business. So it needs to be focusing on the current employer base, both because old employers may go out of business and for administrative reasons, because obviously the collection of assessments is part of the premium process. They're added as a surcharge to premiums.
It makes it much easier for them to deal with the insurance companies because there are many fewer insurance companies than there are employers, right?
Yes, many more. Many fewer insurance companies, absolutely. The only other point I think I'd like to make is with respect to the participating concept, which is sort of floated around. That arose out of the DuPont and the Marcos Weiss-Willos decisions in the appeals court. And those cases, of course, concern employer insureds, they were self-insureds, who opted out. So they are actually examples of a situation where of the gap of the type that is actually ordinarily understood, because there, the employers opted out, and the question was simply, how does that opt-out affect a particular claim? I mean, in one case, the opt-out, there was the claim, the employer opted out, and the question was, does that opt-out affect reimbursement on that claim? And the other one, the employer opted out, the claim occurred, and then the effective date of the opt-out occurred. And the question was, how does that play out? And those are the kinds of situations where there's a gap in the statute. There's no gap here.
Before you leave, can you just take, the pay-as-you-go language appears in a couple of the appeals court cases, and it's a prominent part of their brief. You want to address why the appeals court has the pay-as-you-go confused?
Yes, the pay-as-you-go concerns the overall system, which is funded by employer assessments. And it does not have to do with the historic, payment of claims. It has to do with the funding mechanism. Here, what we have is a payment of a claim arising years ago, which the insurer continues to pay reimbursement on, in our view, should be entitled to receive the reimbursement that goes with those compensation payments that it's making while in runoff.
Okay.
Thank you.
Thank you. Okay, Attorney Martland.
Good morning, Your Honors. May it please the Court, Douglas Martland, Assistant Attorney General for the Trust Fund. At its heart, this case is about deference. The legislature
Talk a little louder.
The legislature left a gap in the statute. The agency filled the gap, and the agency's means for filling that gap.
What's the gap? Because I'm looking at the statutory language, and it seems pretty clear to me. So where are you seeing this gap?
The gap is what to do when an insurer stops fulfilling its obligations under Section 65. And those
No, that's
obligations.
but where, why doesn't the statutory language saying the insurer shall be reimbursed other than the self-employed, self-insured who opt out, groups that opt out, and municipalities that opt out? Where's the gap in that? It doesn't say some insureds, so go ahead.
And, Your Honor, the answer to that question is the court needs to look at both Section 37 and Section 65 in conjunction. The logic underlying your question here is primarily focused on one part of the language in Section 37 that is repeated in Section 65 regarding an insurer making payments. But that ignores the other equally significant components of Section 65, and these are in Section 65.3 and Section 65.5 regarding an insurer's reporting of assessments. And you talked a little bit about that here with my brother, the billing and collecting of the assessments from the employers, and the transmittal of those assessments to the trust fund, which form the monetary basis.
But there are consequences to an insurer who fails to follow those reporting obligations. And one of them is not that they shall not be reimbursed, is it?
So I certainly agree that there are some consequences set out in the statute regarding those, but those consequences do not address the type of situation that we have here, where we have an insurer that at the time of this case began was in runoff and now in liquidation. It would make no sense for the trust fund to be going out and putting a lien on an insurer in liquidation. That is not a productive.
Because they don't pay money into the trust fund. They don't have, and they don't have no one to assess because they have no ongoing clients. The whole thing seems baffling to me. What are you accomplishing by this? They don't pay the trust. The trust fund is paid entirely by employers, right?
Yes, Your Honor.
They're paid entirely by employers. This plaintiff's employer has a new insurance company that's reporting their loss claims, right?
And so I would like to address that point, because I think that gets to the unworkability of the solution that the appeals court proposed in its decision. And this is an equally important part of this court's consideration of the two statutes at issue here, that the appeals court, under the appeals court's new test, every insurer seeking reimbursement, not just the limited class of insurers that we have that would be subject to the trust fund's old rule and the old rule under the appeals court and home, so that would be insurers in runoff and insurers in liquidation, now have to prove that their employer that they insured, and again, using some of the examples from the prior case, in 1990, in 1991, in 1997, in 2005, still exists and is still paying assessments.
Why?
Because that's the rule that the appeals court
That's
articulated.
not the rule, that's just the logic behind why the trust fund's argument is flawed. the trust fund, I thought, was arguing that it was no longer receiving assessments, and the appeals court in response said, no, you're not, because Scully has got a new insurer that's now paying the assessments into the trust fund.
So I agree that for this particular example, Scully is a bit of an exception. It is an employer that has survived, to its credit, a very long time, and it remains paying assessments into the trust fund. No dispute about that. But that is unusual for that particular type of
Where
employer.
is that in the record?
This is coming up subsequent to the appeals court's decision. So if the court wanted specific
No, I'll
facts
stick
about
to
this.
the record here, but you're representing that the lion's share of insured employers whose insurer goes into runoff are defunct?
No.
Okay.
Well, excuse me. What we are trying to articulate here, Your Honor, is that under the appeals court's new rule, if adopted by this court, every insurer seeking reimbursement will have to establish that their employer is paying assessment, because that's the rule set out on page 424 of the
Well,
decision.
let's just say we don't think that that's what the appeals court meant, nor is it a rule or an obligation of the insurer to prove subsequent events. The question we have is whether under the statute, the insurer in runoff is entitled to reimbursements from the trust fund, not how it proves it. Presumably how it proves it is if it's paying the second injury claim, it submits the claim to the trust fund, and whatever portion of that claim it gets reimbursed for. I don't understand why it has to be tied to the continuing existence of some former employer that it used to insure.
So we agree on that point. We do not think that it needs to be tied in any way to the employer. And in fact, that we see as a separate and distinct error in the appeals court. And I think all four parties that have argued today, or three parties technically, would agree on that point, that that part of the appeals court's decision, to the extent it's a rule, is
What
wrong.
language in the appeals, are you talking about the word participates? Is
That
what-
the
it's-
employer still participates in the system. That's how they,
They're just drawing a distinction between the people who opt out and the people who don't. I mean,
respectfully, Your Honor, I disagree. And I think that the appeals court, that reliance on the employer's
So let's say that's not the test. Regardless of how you read it and how I read it, it's not the test. So go ahead.
And this comes back to why there's a gap then in the statute. And fundamentally, if there is a gap, then this court has said, and again, that if the trust fund's approach
But you
is-
identified the gap coming from Section 3, or Part 3 of Section 65. So explain that to me. Where does that gap?
So sections 65.3 and section 65.5 require an insurer to fulfill a set of responsibilities. The trust fund here has said, because this particular scenario is not addressed anywhere in the statute of what happens when an insurer just stops fulfilling those responsibilities.
But no, I thought the insurer is fulfilling the responsibilities under, I thought it was Form 50, which contains no information because there's none to give.
So to the extent that they are reporting zero assessments, they are not fulfilling their other responsibilities, which is billing and collecting and transmitting funds to the trust fund.
So they have to bill and collect what?
They
from
have,
whom?
from writing existing policies.
But they have none.
Exactly.
So hold on.
Those are obligations. That's
So
a
I have no
precondition.
existing policies out there. Am I violating my obligation to
Again, Your Honor,
65.3 and 5? I don't understand that. I mean, it's as if they're no longer an insurance company in Massachusetts. They're in runoff. They have obligations under the policies that they wrote, and so they're paying them.
right, and
But they have no information to report under 3 and 5.
separate question is whether, because of their change in status, they should be eligible for reimbursement. And the trust fund's position
So
is that there are.
does section, gosh, what section is it, 2? Does section 2 say anything about eligibility for reimbursements conditioned on 3 and 5?
No, section 2
So
does
you're
not.
reading that into the statute and then finding a gap from the reading it in?
I disagree, Your Honor. We are,
No, I'm asking,
Yeah,
I'm
yes,
not
yes.
I'm trying to understand your position, because you've identified a gap, but I'm still not seeing it in 3 and 5.
The point is that the language in section 65(2) does not address this scenario. That is the gap.
Can you, and Justice Winter, are you done? 'Cause I don't want to cut you off on this.
I think I have the information I'm going to get.
Okay, so tell me practically, okay, because I always find the language makes more sense when I understand the reality underneath it. So the reality here is these insurers they're not selling any new policies anymore.
Correct.
And so, they are fulfilling their obligations to the employees, which is what the whole system is designed to do. They're paying out these COLA benefits. What is it that they're not doing in the real world that is somehow hurting the system? Give me, because I feel like this was a practical problem and a practical solution. I don't see what you're talking about. Go ahead. Tell me what it is they're not doing that meaningfully harms the Workers' Compensation Trust Fund. Because again, I get how important that fund is.
And to understand your question, Your Honor, I think we have to back up to home, which is a little different than this case. This case only involves an insurer in runoff. Home involved both an insurer in liquidation and in runoff, those stages as the company progressed to liquidation. And the rule in home originally came about because the insurer, as you discussed in the last case, was no longer making the payments to the injured worker. And the reviewing board there explained that when you're not making the payments and fulfilling your statutory preconditions to reimbursement, you're not entitled to reimbursement.
Of course. Obvious.
Okay, but that's it. And the reviewing board there continued that logic because that arises out of both sets of obligations in section 37 and 65.
Again, speak in practicalities. They're not doing something, and why is that meaningful? They're not reporting on clients they don't have. In this context, I get the other context. Give me a real-world example where there's harm here.
And I think at the end of the day, Your Honor, this is really about apportioning the risk of loss to the system, not necessarily to the fund, but to the system.
But the system apportions the loss among employers. It doesn't apportion the loss against insurance companies. Or does it? Again, go
So
ahead.
I agree that the system apportions the loss against insurance companies and the
Employers, not
Sorry, excuse me, employers. And that the trust fund's rule here was created to anticipate that risk of loss and to resolve it. There is a separate mechanism that you talked about in the prior case for resolving situations where an insurance company goes into liquidation. That's a separate legislative scheme created by the legislature.
Again, I'm giving you an opportunity, because I like to understand, I don't want to harm someone out there, and I don't want to harm the fund, but I need you to explain how the result he's arguing for, which seems to be consistent with the statutory language, is somehow damaging here. And so far, it's still incredibly esoteric to me.
And so one portion of that, Your Honor, is the administrability of the rule. The trust fund, as explained in our briefing here, determines eligibility for repayment by looking at those several criteria in section 65.3 and section 65.5 that I was referring to earlier. So the assessments, the report, or the billing, the collecting, the transmittal, all of which.
Yeah, you're gonna run out of time. Practically, we know they have no ongoing clients. So all we have is the existing ones before they went into this status. So tell me how the harm is by having them not file something.
I'm attempting to distinguish between the harm and the administrability, and I do think that the administrability of this rule is important. The trust fund here isn't an entity that should be going out there and identifying the status of every insurer that's operating in the Commonwealth. The way that they have used, a shortcut you could say, to identify that status is to look at situations where an insurer is meeting these criteria of no longer billing, collecting, and transmitting assessments. Again, we have the zero, like we're talking about here, as a shortcut for identifying that they are on the path or in liquidation. And so that again is where the real harm occurs. When the insurer hits the liquidation and they're no longer making the payments, they would be
They
receiving.
don't make the payments, the employers make the payments.
Exactly.
So
But under,
again, what is the real-world harm you're describing? They don't make the payments, and there's a successor insurance company for that employer. So
so I agree, but the fact pattern in home was the insurer in
Right, so
liquidation.
that makes the second part of home entirely dicta, right? Because the insurer in home was not actually paying anything. It was actually just asking for money in reimbursements for money it had not paid out.
So, no. And the reason for that is there were claims for both periods in home. So there
Okay.
was claims that arose while the insurer was in runoff, and there were claims that arose while the insurer was in
Thank you.
liquidation.